advocacy in areas such as socio-legal studies and ecological economics. Through this forum, we hope to spotlight such promising intersections and foster academic engagement across and within disciplines. This evening marks the first of 15 lectures planned for this academic year. Lectures will be held fortnightly, with the next one scheduled for 1st of August. I would like to take this opportunity to invite faculty members to volunteer as speakers for upcoming sessions. If interested, please feel free to express your willingness by the end of the lecture today. We can work out the details over the next couple of days. With that, I sincerely hope this initiative receives your support and enthusiastic participation. It is now my honor to invite our speaker for today, our dear Vice Chancellor, Professor Dr. D.Prakasa, to deliver the inaugural lecture. Thank you.
As per contextual, the interpretation of the Constitution by the judges. And what is Constitution in any country is Constitution as understood by the judges. So Justice Huggs of American Supreme Court said that what is US Constitution? It is what the judges say it is. So Constitution is not the Constitution in the text. What the judge says about the Constitution is the Constitution. The same ideas is also applicable to Indian context. So we all know the Indian constitutional making process. Constituent Assembly Drafting Committee under the chairmanship of Dr. B.R. Ambedkar, Alladi Krishna Swamy, Sir B.N. Rao as constitutional advisor. So many members are there, and the constitutional making process was influenced by the culture of the country, the impact of the practices of the other constitution. When the Constitution of India was being made in mid-19th century, 1950s, the constitutional makers had the 150 years experience of the American Constitution before them. The functioning of American Constitution was with them, and they had the unwritten constitutional practice considered as the oldest modern democracy, the Britain. And the experience, the values for which the Indian society fought against the British colonialism was also there before the constitutional makers. So for what values the Indian society fought against British colonialism was materialized, was realized through the enforcement of the Constitution, particularly the Bill of Rights model adopted into the Constitution in the form of fundamental rights. So that's why the constitutional makers have the experience of different constitutions, the history of the country, and more particularly they wanted to have the democratic model. So we know democracies are two types, direct democracies and indirect democracies. So direct democracy is very difficult. People elected their representatives. Indirect democracy have two forms, presidential form and parliamentary form. So American Constitution has presidential model, whereas Britain has parliamentary democracy. So we adopted parliamentary democracy as our model. And again, as per the implementation of the democracy is concerned, social democracy and liberal democracy. So under Indian Constitution, initially we adopted social democracy by following the socialistic pattern of society through direct proportional substitute policy. Of course, in post-liberalization era, we have a somersault. The social democracy was metamorphosed in the form of liberal democracy. So in the background of, again we have almost 35 years experience of, 35 to 40 years experience of liberal democracy without changing a single word of the Indian Constitution. We have a metamorphism, a somersault, as I would say, from social democracy to liberal democracy. And the Indian Supreme Court contributed much to the development of constitutional culture, constitutional morals, constitutional philosophy for the last 75 years of its experience. So we have all these things before us and we are examining the evolution of constitutional jurisprudence, particularly by the courts as I just introduced, and how this constitutional jurisprudence has been evolved by the judiciary under the influence of various constitutional theories in particular, apart from political theories, social theories and economic theories, which have also been influenced in understanding various principles of the Constitution. So here I made a small attempt in understanding the developments and the constitutional values under the Indian constitutional system. Particularly when we are aware of the constitutional model, and you know the first slide, what I said, the constitutional jurisprudence is nothing but the case law developed by the Supreme Court over the years. So here we have to understand, after having 75 years experience of the Indian constitutional function, where it faced several challenges and it stood for times. The success of Indian democracy is the success of the Indian Constitution. So how the Constitution was created, how the Constitution was nurtured, how the Constitution was understood, how the Constitution was strengthened is also to be understood in the process of understanding constitutional jurisprudence. And we know some of the different dimensions of the Constitution, particularly encouraging constitutionalism and transformative justice. As you know, what is justice? Justice is, in simple way, a just thing. Justice means just thing, of course, for the convenience, civil justice and criminal justice, and for another aspect, justice is understood as corrective justice and distributive justice. Corrective justice is nothing but criminal justice system. when a society is functioning on established norms, if any particular person has deviant behavior, correcting the deviant and bringing him to the mainstream is the object of correctional legislation, is the purpose of corrective justice. If correction is not possible, that individual will be extinguished by way of awarding death penalty. So the second aspect of justice is distributive justice. In the words of Aristotle, then it was developed as social justice. Now we are talking it as transformative justice. So transformative justice is a mechanism developed in the constitutional system for enforcing social justice. So we have political, economic and social justice guaranteed under the Indian Constitution through our preamble and declaration. We the people of India, having solemnly resolved to constitute ourselves a sovereign, socialist, secular, democratic republic, and ensuring its citizens justice, political, social and economic, equality of status and equality of opportunity, liberty of thought, expression, faith, worship and belief, and to promote them among them all, fraternity, assuring the dignity of the individual and integrity of the nation. So the constitutional values, the constitutional goals set out in the preamble and declaration, there were several attempts in the constitutional mechanism to enforce these constitutional goals which are set out in preamble. That's why a lot of debate went. When a word was added to the preamble, like socialist and secular, can in future the parliament remove any one of the words which are already there in the preamble? So in order to strengthen, in order to fortify the spirit of the constitutional goals, a new goal may be added. But it is like common hodgepodge of family income of a particular Hindu family setup, under undivided Hindu family under taxation system. So you can throw some money into the common hodgepodge, but you cannot take at your will. Like that, you can throw a word, you can add a word to preamble, but you cannot remove the word from the preamble. That is what is the debate recently in Subramania Swamy case also. Supreme Court gave the socialism guaranteed in Indian Constitution is simply the Supreme Court understood removal of inequality is social justice what the Indian context, what the Indian constitutional text promotes. So that's why the enculturing constitutionalism and transformative justice, constitutionalism is antithesis of arbitrariness, authorized form of government, authoritative form of government, and unaccountable government. It is antithesis of these undemocratic values, whereas constitutionalism promotes accountability, limited government, and responsible government. In the backdrop of right to information and others, we have this transformative transparency, good governance are also added as part of this promotion of constitutionalism. And you have enculturing constitutional values, morals and philosophy. So these are developed not in a single day. The culture, the product of the Indian culture developed these constitutional values and morals and philosophy, and we have to understand. And providing social justice, of course, you have already directed principles of state policy. And of course, the value of democracy we all understood. Democracy is not a way to elect the government. It is a way to life. Democracy promotes a way of life rather than providing a mechanism to elect a government. So democracy, that's why man's love for justice makes democracy possible. But man's inclination to do injustice makes democracy necessary. So the human societies moved from rule of man, authoritarian form of government, to rule of law, to democratic form of governments. So if democracy fails, utter disorder, stick to democracy. That is the value of democracy. So that's why we adopted the democratic form of government, where already we have the separation of powers, whether sovereignty is divisible or indivisible. So ultimately various jurists came to the conclusion that sovereignty can be divisible. So divisible in the sense we have center-state relations regarding distribution of powers, distribution of sovereign powers at central level and state level. And we have separation of powers in the name of legislature, judiciary and executive. And of course Edmund Burke, he was the person, while addressing the British Parliament or seeing the gallery, press in the gallery, first time used press as fourth estate. So you are the fourth estate. The first three estates are legislature, judiciary and executive. The fourth estate is press. Of course, in post-liberal democracies, we have fifth estate. That is what is NGOs, civil society. Now civil society as a fifth estate plays an important role to transform the society for better tomorrow when the state fails. In a liberal democracy, now the state is minimal state. Minimal state and more market. Less state, more market is the present basis for liberalized democracies in the world. So that's why the independence of judiciary provided a better, accountable and ensured government. So that is what is the part of. Of course, independence of judiciary is considered as the more valuable institution for promotion of the democracy. That's why in Keshwananda Bharati, while arguing Palkiwala, while arguing the case, Palkiwala mentioned, if Parliament was allowed to amend the constitution at its will, the executive-ridden Parliament, Indira-ridden Parliament, can amend the constitution, amend the constitution, and end the constitution. So, Parliament amendment power should not be made unlimited. Of course, there is an interpretative development as far as that aspect. So, the second aspect is how the constitutional interpretation. I already told you what court understands is the constitution, not what the text says in the constitution. So, as long as there is no controversy, the constitution can be understood through the literal interpretation of those various articles of the constitution. But when the constitution is to be really understood, really enforced, then we have to understand the contextual understanding of the constitution, and that's why Canadian Supreme Court understands that constitution is not a dead tree, it is a living tree. Constitution is a living tree. Living tree approach. So it has so many branches developed, so many leaves developed. So constitution can be developed like a living tree. So that is what we understood in the Indian constitutional interpretation also. So as you know, the parliamentary democracy, supremacy of the parliament and the supremacy of the constitution. The problem with the constitutional interpretation in Indian context is we adopted written model, we adopted Bill of Rights, we adopted judicial review, we adopted constitutional supremacy from American constitutional model. So you know the history of American constitutional development, particularly right from Marbury versus Madison. Justice Marshall gave that particular idea of judicial review. Yes, legislative action is there, executive action is there, but judiciary has power to review the legislative action and executive action to validate or invalidate that particular actions. From then onwards, the democratic constitutions understood the value of the power of the judicial review, and wherever the judiciary wants to understand the constitution, gives the judiciary is accountable to the constitution. Legislature is accountable to the people because people are electing. They represent it to the legislature. Legislature elects the government. Executive is accountable to the legislature. Whereas judiciary is accountable to the constitution itself. So that is what is the strength of judiciary. So when there was a debate, particularly D.Prakasa and Sajjan Singh, the Supreme Court of India did not interfere in the textual interpretation of Constitution. And Supreme Court of India allowed in these two cases that Parliament has unlimited power. It can amend any provision of the Constitution. When the first constitutional amendment was challenged in D.Prakasa, when seventh constitutional amendment was challenged in Sajjan Singh, the Supreme Court, under the impression that the national leaders who fought for independence were at the helm of affairs in the executive. All the cabinet ministers, prime ministers, chief ministers, governors, all these were the immediate independent fighters. So the judiciary has a lot of respect. So it did not interfere in the executive actions and legislative actions frequently. But Justice Madhurkar in Sajjan Singh raised some doubt. Tomorrow Parliament may amend the constitutional provisions at their will. So including abolition of the constitution, what will be done? So by the time of Golaknath, that's the state of Punjab, particularly in that case, Justice Kokasumbarao, Justice Sedretullah, these people are there. But because we have parliamentary democracy, and what England Parliament has the power, can also the same power we can exercise here. Parliamentary privileges simply, even the problem is there, non-codification of parliamentary privileges. What the parliamentary privileges enjoyed by the British Parliament can also be enjoyed by the Indian legislatures. So, Parliament was given the power to amend under 368. Three types of parliamentary, three types of constitutional amendments were provided: simple majority, two-third majority, and two-third majority with majority states ratification. That is enough to amend the constitution. Then, the interesting point, why Nambiar is given such type of great place, the father of advocate K.K. Venugopal. Now K.K. Venugopal is also 93-year-old gentleman so he is promoting the cause of legal education and encouraging students by way of establishing Nambiar chair. Nambiar, advocate Nambiar, actually these were the already developed what we say thoughts of the different floras, platforms. Professor T.S. Ramarao attended a lecture at Benares Hindu University, where German professor he got developed a thought. Every written constitution has inherent limitations. So, written constitution cannot be amended at the will of a particular empowering authority. It has its own inherent limitations. The text of the lecture was handed over by Professor T.S. Ramarao, Madras University Legal Department of Law's head, to Advocate Nambiar. Advocate Nambiar gave the text to Justice Prakasa. After reading the judgment, the text of German professor, Justice Prakasa was convinced that it was high time to impose the limitation on the Parliament power to amend the Constitution. So he imposed the limitation. Subject to the fundamental rights, Parliament has power to amend any other provision of the Constitution. Preamble was not part of the Constitution and all these limitations were there. So that's why after that the comment is Prakasa judgment is correct, but reasoning is wrong. Of course, there is no time to discuss those reasonings and others, but this was further enhanced when the constitutional amendments, 24th, 25th, 27th constitutional amendments came. Those were challenged in Keshwananda Bharati. Recently, when Keshwananda Bharati died, throughout the country, he was remembered. His photos were circulated in the social media also. The reason is Keshwananda Bharati, a holy saint of Kerala, when his property was taken by the government, he challenged those this thing. Of course, in the list of the cases, his case is the first case. So the case is popularly known as Keshwananda Bharati versus state of Kerala, where the basic structure was developed. Of course, all these were developed because of, these are all part of constitutionalism. These are part of constitutional structure. So in Keshwananda Bharati, if you are aware of the judgment, the Godin concept of sovereignty, the Austin concept of sovereignty, Bentham concept of sovereignty were discussed, and whether the original constitution has the constituent power or the Constitution of India with subsequent amendments has the constituent power. All these were discussed in Keshwananda Bharati. We know 13 judges, so far now it is the largest bench, out of which 11 judgments came. 2 judges wrote one judgment, another 2 judges wrote another judgment, and 9 judges wrote 9 individual judgments. If you go to Supreme Court library, which was started as a part of 50 years functioning of Indian Supreme Court, a 2-storied building was opened where all the important case laws and various chairs used by the judges and others, all these things were there. In one open hall, 13 judges' signatures of Keshwananda Bharati, first page, was depicted on the paper. Because it is the historical monumental judgment. So the judgment is followed by several other countries' Supreme Courts, just to understand the strength of democracy. So here that's why, as part of in order to understand the constitutionalism, simultaneously we have to understand various constitutional developments from time to time. So here, after Keshwananda Bharati, you know, election Indira Gandhi versus Rajnagar, 39th constitutional amendment was challenged. The spirit of the amendment is President of India, Vice President of India, Lok Sabha Speaker, Prime Minister of India's elections cannot be challenged in any court on any ground. The judicial review was taken away. On the advice of Palkiwala, this amendment was brought. Kalkiwala was an advocate for Keshavananda Bharati and other petitioners, where he argued strongly about the basic features of the constitution, basic structure. Suli Sarabji, while his junior, while giving tribute to Kalkiwala on his death, discussed the developments, how the discussions were there regarding the evolution of basic structure. So, in Indira Nehru Gandhi, popularly known as the elections case, the Supreme Court struck it down, treating just fair and free elections are the part of basic features. So when 42nd Constitutional Amendment was challenged in Minerva Mills, of course 4-1 judgment. So until by the time of Minerva Mills, 3 views were emerged, 2 views were emerged at least. Fundamental rights are enforceable under Article 30, whereas directives are non-enforceable under Article 37. So when there is a conflict between enforceable and non-enforceable rights, enforceable rights have to be promoted. The simple, why the jurisprudential values are relevant in understanding the constitutional or other legal provisions. So here, the positivistic thought says that law is a sovereign command which has sanctioned, of course further developed by Hart in the form of system of rules. So the rule which is recognized can become the law, and that is to be understood as it is. So fundamental rights are enforceable, directives are non-enforceable. Conflict, fundamental rights are to be promoted. You take what we say, Mohammad Qureshi versus State of Bihar, Ray Kerala Education Bill, and all these were there, in which the first view was supported by the Supreme Court. The second view is because of the new article introduced in the Constitution text by way of Article 31C, 31 capital C. When ordered to implement Article 39B and C, prevention of concentration of economic power and material resources redistribution. If any legislation is brought by the central government or state government, even though that legislation is violative of Article 14, 19, at the time 31, that legislation was not treated as invalid. That is what is the spirit of Article 31C. It was challenged in Keshavananda Bharati. The court said that the first 7 out of 13, 6 judges held that 31C in toto invalid. 6 judges held that 31C in toto invalid, valid and invalid. The 13th judge, Justice H.R. Khanna, Hansraj Khanna, accepted first para with the first 6 judges, last para with the remaining 6 judges. He approved Article 31C as valid, but removal of judicial review is violative of basic structure. So in order to see whether the legislation is brought to implement Article 39B and C or not is to be reviewed by the court. That's why sometimes regarding Article 31C, it is considered as single judge judgment, even though 13 judges reviewed that particular Article 31C. So here, to give preference to directives, what 42nd Constitutional Amendment did when it was challenged in Minerva Mills case, in the place of 39B and C, in order to implement any directive of the directive principle of the state policy, if a legislation is brought, even though that legislation is violative of Article 14, 19 and 31, that was valid. The court, 4 judges held that it is unnecessary to see any confrontation between fundamental rights and directive principles of the state policy. harmonious construction is to be made. Where jurisprudence is relevant here, you have bounds conflicting of interest theory. Society is full of conflicting interests. Law is a balance among the conflicting interests. Basic structure is a balance in the Houdinian sense of understanding of the law. When there are conflicting interests, law is a balance. Basic structure is a balance in Keshwanandapara. Whereas harmonious construction of fundamental rights and directive principles, it is unnecessary to see any confrontation between part 3 and part 4. Both are supplementary and complementary to each other. Harmonious construction. Houdinian theory. Hound's sociological theory of understanding, social engineering. So here, the minority judge P.N. Bhagavati, he wanted to give more importance to directives. Is minority, fifth one is minority judgment. When fundamental rights are individual rights, directives are meant for society, societal rights. When there is a conflict, let the societal rights be developed. That is his minority view. And of course, the majority view still prevails in order to have the relationship between fundamental rights and directive principles of state policy. So in the process of constitutional principles understanding, the judiciary developed several theories. If you want to go to understanding of Article 12, different doctrines were developed. Doctrine of what we say instrumentality is there, particularly whether a particular organization will come under the state or not. Then Article 13, judicial review is there. Directly it was provided in the Constitution. If you are aware of the interpretation of Article 14, several doctrines were developed by the Supreme Court. Particularly, reasonable classification, doctrine of arbitrariness. Now, latestly, you can have this particular, then there is a conflict between opportunities provided, reasonable opportunities, and distributional equal. So how the opportunities are seen to reach the people. Then the third aspect, equality of result. So what will happen after some time in that particular process of what we say understanding of reaching the goals, equality of result. So when equality of result fails, then it can be understood as violative of Article 14. So recently we also understood various judgments in understanding the dynamics of equality. So of course limited time is there. We have 5 aspects of constitutionalism. As I discussed about supremacy of the constitution. Until Keshwananda Bharati, there was a doubt whether under Indian constitution parliamentary supremacy was there or constitutional supremacy. In unequivocal terms, the Supreme Court declared that supremacy of the constitution is the basic structure. So that is the first aspect of this thing. Then we have representative governments and responsible governments. So we have that is also part of constitutionalism. Then we have distribution of powers between center and states. Then we have protection of individual rights, particularly part 3, fundamental rights, and part 4, directive principles of state policy, both constitute the conscience of the Indian Constitution. So in order to understand the constitutional jurisprudence, you have to understand the spirit of fundamental rights, the spirit of directive principles of state policy. That's why now there is no limitation regarding amendment or taking away of any fundamental right. Article 31, right to property, was removed and a new article was added, right to free and compulsory education, right to primary education, Article 21 capital A. as a result of Unnikrishnan judgment. So here that's why the protection of individual rights is part of constitutionalism, constitutional jurisprudence. And we know Article 32. That's why when B.R. Ambedkar said, if anybody asks me, what is one article without which there is no meaning of Indian Constitution? Without having any hesitation, I can refer Article 32. Article 32 provides constitutional remedies. When a person feels that his fundamental right is violated, he can approach. Coming to the Supreme Court itself is a fundamental right. That's why there is a lot of discussion about habeas corpus case. It is 4-1 judgment. The 4 judges unfortunately held that when national emergency was there, the immediate effect is suspension of Article 19. If President of India further intends, he can suspend other fundamental rights also. Accordingly, all the fundamental rights were suspended. This year we are understanding how many years it is. I think 50 years of emergency. The black mark of the Indian constitutional democracy, Indian democracy, democratic form of government. So here, Justice H.R. Khanna, who gave the minority judgment, it is immaterial whether constitution is there in a country or not. It is immaterial. What are they? So no sooner a human being is born, he or she acquires inalienable sacrosanct values which cannot be interfered, which cannot be negotiated even by the state. So of course it is minority judgment. So after emergency was over, in Maneka Gandhi versus Union of India, the minority judgment was overruled. The habeas corpus judgment was overruled, and recently Junior Chandrachud had an opportunity to get rid of the particular Senior Chandrachud's judgment of habeas corpus. That was also mentioned. So here that's why regarding protection of fundamental rights are concerned, it is the important aspect of constitution, how the constitutionalism is to be strengthened under the Indian Constitution. So some constitutions may have the constitutionalism, but some constitutions may not have the constitutionalism. The constitution which has the constitutionalism is the true reflection of the democracy in that country. So that's why it should be there. And again, we have politically neutral institutions. Having politically neutral institutions is also part of constitutionalism. So independence of judiciary and election commission, and particularly Controller and Auditor General, CAG, Attorney General of India, Civil Services, these are the neutral agencies to promote and strengthen the democracy, democratic values in the country. And we have, I already told you, transformative and creative justice. Here one should have to understand the jurisprudential understanding of the constitutional process. The reason is a common understanding. If any person understands, if any jurist, if any law student, a law professor or law student or law teacher, research scholar, understands the constitution with jurisprudential principles, he can be considered as constitutional expert. How can we say that a person is a constitutional expert? The person who has the capability, ability to understand the Constitution of India with the jurisprudential values, to take any Supreme Court judgment without having the jurisprudential understanding, the judge cannot reach to the solution. So either he may be applying positivistic principles right from Bentham, Austin, or to the modern context of the positivists, particularly H.L.A. Hart and Hans Kelsen. Hans Kelsen tried to understand the what we say, constitution in any country is the grand norm. So, fundamental law of the land. The constitution or maybe two or more constitutions may be there. All these are promoting the fundamental law of the land, basing upon which your other legal systems were established. So, it is in a pyramidical way, and every subordinate norm depends upon another subordinate norm. Ultimately, all these subordinate norms are tested by the touchstone of the constitution. That is what is the Kelsenian purity. If you go to heart, particularly law is nothing but the combination of primary and secondary rules. Primary rule is substantial law, secondary rule is procedural law. In order to recognize a particular rule as law, Hart developed this particular recognition of rules. So unless a particular rule is recognized, it cannot be considered as law according to Hart. All these principles, even International Court of Justice, when giving the judgment in using or threatening to use nuclear weapons is gross violation of human rights or not. All these juristic philosophy and thought were discussed by the judges in order to have their own explanation for the reasoning behind their giving judgment. That is very, very important. So, that's why when you understand the jurisprudence, when you understand the legal theory of a particular society, if you are able to understand the legal theory with the help of any constitutional provision, you are a jurist. Who is a jurist? Who is a constitutional expert? A person who has a combination of acquisition of knowledge in both jurisprudence and constitutional text of any country. So that's why, as per as the constitutional theory, constitution after all in any country is theory of rights. Constitution creates the rights. Constitution creates the duties. Right-duty correlation. Every right has corresponding duty. You have fundamental rights. People have fundamental rights in India, whereas the corresponding duty is laid down on Supreme Court of India, Apex Court, Article 32. It is the duty of the Supreme Court to protect and promote the fundamental rights. That's why Supreme Court of India in a parliamentary democracy, while creating basic structure, was not in a position to substantiate it, creation of basic structure with proper reason. But later on, in Quilly versus State of Tamil Nadu in 2005, Supreme Court was able to give the reason for its judgment in Keshwananda Bharati. The reason is, it is the fundamental duty of the Supreme Court to protect and enforce the fundamental rights. In the process, Supreme Court can create any mechanism. That is what is Article 141. Law declared by the Supreme Court of India shall be binding on all the other courts. Whereas 142, justice. To do complete justice, Supreme Court can declare anything. The recent example of stopping legislations passed by the legislature, by the governor. The reason is Supreme Court is accountable to the Constitution. So Supreme Court has to see smooth functioning of the Constitution. If any deadlock is there, that's why when in Bora Singh case in Arunachal Pradesh, when Supreme Court of India passed an order to arrest the Speaker of that House, the advocate of the Speaker commented, today it is the 1000 days dark nights in the democratic history of India, where the Supreme Court of India ordered the arrest of Speaker. Then the concerned judge made a comment. Why can you think, why do you comment in such way? Why can't you think it is the day on which thousands moonlight work flourish. The reason is, in a Indian democracy, under Indian constitutional system, Supreme Court of India is in a position to pass an order of arrest of the Speaker. The same thing was continued here also. In the making of the legislations, even without the signature of the governor, made by me, they were converted as valid legislations. What power Supreme Court has? Supreme Court has that power under Article 142 to do complete justice. Supreme Court of India can declare anything as law. Particularly in Uttar Pradesh, particularly Kalyan Singh versus the then Chief Minister, who was appointed after the dismissal of Kalyan Singh government. First time Supreme Court of India ordered the Speaker. Until then, what happened? The test is to be the legislature, the particular Chief Minister has the support of the legislature or not. He is tested in the before governor. Because of that, Kalyan Singh versus the then Chief Minister, he is also available now. I think he became governor. What happened? So he was dismissed. So in that judgment, floor test is the correct principle. Whether a Chief Minister has majority or not is to be proved in the floor itself. So in that case, Kalyan Singh and that another Chief Minister who was newly appointed were given 2 checks. It is sent to the Speaker. Floor test was conducted. The dismissed Kalyan Singh had the majority. Though the moment Speaker declares the decision, he continued as Chief Minister. No formality of swearing of ceremony again and accepting the resignation of the newly appointed Chief Minister. The reason is, Supreme Court has complete power regarding to do complete justice under Article 142. So that is very, very important. So that's why particularly I covered one of the aspects of this particular dimension. Actually we have transformative justice, one of the concepts to be discussed at length, and the jurisprudential values, law as dictate of God, nature or reason, reasonable classical Kant understood that law is a categorical imperative. So hypothetical imperatives are, emotions are varied from person to person, but there is categorical imperative which guides the society. Law as dictate of reason. Until 19th century, until Immanuel Kant comes, ancient natural thinking, medieval natural thinking, then Jeremy Bentham came. He destroyed the natural law philosophy. Who is this God? Where is the secular definition of understanding God? So he criticized natural law philosophy as silt nonsense. That's why Bentham is the first destroyer of natural law thought, whereas Immanuel Kant is the last protector of natural law. The reason is, in the place of dictate of God, in the place of dictate of nature, Immanuel Kant was able to implant law is dictate of reason. So you go today's Article 14 interpretation, reasonable classification. If you go to interpretation of Article 19, reasonable restrictions. If you go to Article 21, law is just, fair and reasonable. So the Immanuel Kant, any human rights activist, any natural law philosopher is considered as neo-Kantian. Whether it is Mahatma Gandhi or Radbridge or whatever the modern dynamic interpreter of the constitution by way of judicial process, a dynamic judge, he is considered as a neo-Kantian. So Kant philosophy still rules the mankind. The entire human right jurisprudence developed by the Kantian categorical imperative. That is one thing. So here, that's why we have considered law and legal system are the product of culture. Law and language are silent growth in the society. How can we say a particular language is to be developed in a particular area? So law is also developed. That is what is the historical contribution. Then we have sovereign command sanction with the system of rules I already discussed, and sociological school. Law is social engineering. That's why until 1980, Boundinian social engineering and law is a balance among the conflicting interests is buried. The question comes, when balance is not possible, whose interest is to be sacrificed for whose development of whose interest? Then particularly Dworkin came. Dworkin wrote a book, Taking Rights Seriously. So he classified the rights. Some rights are strong rights, some rights are weak rights, peripheral rights. When there is a conflict between strong right and weak right, let the strong right be promoted. What is strong right and what is weak right is to be decided by the society. As a representative of the society, say for example, X versus Y, Z hospital case. X is an HIV infected patient, filed a case against Y and Z hospital. Y is the woman who cancelled the betrothal on knowing the information that X is an HIV infected patient. Z is the hospital who violated the Hippocratic oath and revealed the information that X is suffering with HIV infection. Then initially he went to consumer forum, then again he came to the Supreme Court. So here X contention is, I have a right to marry, establish family, procreate children under Universal Declaration of Human Rights. Woman's contention is, she has not only right to marry, but also having healthy marital life. So when there is a conflict between right to marry and healthy marital life, the Supreme Court accepted with the strong right contention of the woman. So when they say, for example, environment and development, sustainable development is the balance between environment and development. So if there is a conflict, development is to be sacrificed for the sake of environment, or environment is to be sacrificed for the sake of development. So here Dworkinian sense of strong and weak rights analogy has to be taken. For some context, environment becomes strong right, then development is to be cancelled. Narmada dam issue also the same thing is there. Right to development was promoted where some of environment issues were objected, but Supreme Court accepted that sustainable development is not possible. Let us think the problem in the light of strong and weak rights. Even so far now, right to life and personal liberty are strong rights. In India, right to privacy until 2017 was considered as a weak right. But now, after Puttaswamy, it also became a strong right. So here, that's why the other aspects of the problem, constitutional jurisprudence, how the constitutional values are to be promoted through democratic way of life. So unless everybody has conscience of developing democratic values and stick to this thing, we cannot consider. That's why we want equality, but we will not allow others to have the equality. So all these differences are there. Then another aspect of this issue, particularly dharma jurisprudence and how the dharma was developed in the past. Dharma duty, but dharma is also justice. So we have to understand the Rawls theory of justice and Martha Nussbaum's frontiers of justice and Amartya Sen's concept of justice. Simple thing. John Rawls argues that fairness is the justice. So in social democracy, justice can be reached through equality. Equality is the means to achieve the justice. In liberal democracy, liberty is the means to achieve the justice. That's why we developed two principles of justice. Some societies achieve justice through equality. Some can have justice through liberty. And Martha argues that before improving human capabilities, how can we expect that human beings can enjoy the rights? In order to make the human beings competent to have the accessibility of the rights, that human being first should be promoted with human capability. That's why she gave first priority to food security, primary health, primary education. So you take any, particularly from 1995 to 2010, various legislations were brought throughout the world. In India also we had a lot of legislations implementing these three values. The Human Development Index of UNO also has the same analogy of Martha in order to understand the human. Previously, particularly the gross GDP of a nation is taken into account whether it is developed or not. Now, how the right to primary health, how the right to primary education, how the food security in a particular country are ensured basing upon their indicators. Now we are measuring that country is developed or not. That aspect is there. So that's why we have to understand. That's why I will conclude my small discussion with the words of Socrates. When there was a question before Socrates and disciples, what is justice? Different people have defined justice in different ways. But Socrates understands. In order to understand justice, first you have to understand the state in which you are living. So state and justice are two sides of the same coin. Unless you promote the justice, you cannot have the strong state. Thank you very much for giving me the opportunity. Thank you. I hope this is a good beginning in our institution. We can have more and more lectures of more and more justice.
Which is a good thing. So let's hope to continue this. Thank you very much.